Honorable Court of Tennessee is now in session. Please proceed.
Good afternoon. Glad to have you here on this lovely day. I'm sure there's no place you'd rather be. We'll hear the cases as they're listed in the docket. When you're the appellant, please remember you can reserve time for rebuttal if you want. We are live streaming, I believe, the first two cases. The last case will not be live streamed. Unless there are any other announcements or anything. Nothing. Okay. Well, please call the first case.
French Broad United Methodist Church et al. The Holston Annual Conference of the United Methodist Church et al.
Good afternoon. I'm attorney Brett Stokes from the Knoxville Bar Association, and I represent the Appellant's Bethel Church in this matter, and I would like to reserve 7 minutes for rebuttal, if I may.
Do you all allow 7 minutes? We only allow 5 in the middle
5
section.
sounds good.
5? Okay.
Yes, sir. I'm sure our esteemed justices have reviewed the record and read our briefs. The appellants will rely heavily on all information in the record, our initial brief, and our reply brief. As I do not have enough time to address the entire voluminous record in this matter, I'm going to try to boil down our case to 3 main categories and reasons why the appellants should prevail on appeal. Boiled down, these 3 issues are, as stated, constitutionality, the second would be illegality in public policy, and the third is the facts and the evidence of the case. The first issue as to constitutionality, the appellants aver that they should prevail in this appeal because respectfully, the Tennessee Supreme Court's application of Jones via Kojic is unconstitutional because said application violates the Equal Protection Clause and the Establishment Clause of the United States and the Tennessee Constitution. When I say Jones, I'm referencing the United States Supreme Court Jones versus Wolf, which can be found at 443 U.S. 595, which was published in 1979. When I say Kojic, that is short for Church of God in Christ versus Ellen Haley Ministries. Kojic can be found at 531 Southwest 3rd, 146. And again, that's a Tennessee Supreme Court case from 2017.
Okay, which case are you saying is wrong?
I'm saying Kojic's application, according to what was pronounced in Wolf, is the application of it is unconstitutional. And when I reference that, what I'm saying is Kojic's interpretation is that basically an individual can enter into a legally cognizant document and that's sufficient. That clearly makes no sense because it takes 2 parties to enter into a contract. It takes 2 parties to form a deed and to transfer property or to create a trust. I'm just saying, as applied, it's unconstitutional, and I'll explain further. As to the Equal Protection Clause, boiled down, basically, the constitutional amendment states that all laws shall apply equally to all citizens, i.e., every man, woman, young adult, partnership, corporation, or a nonprofit organization such as a church should have to follow every title of the law to the same degree. If they violate that law, there should be consequences. The matter of Martin versus the Beer Board of Dixon is found at 908 Southwest 2nd, 941, and is a Tennessee Supreme Court case from 1995. In that case, Justice Cope gives us a great history lesson. He tells us what the purpose of the constitutional amendments, and specifically these 2 that we are addressing, are. He says the purpose is that they embody the fundamental values and their citizens' common goals for constitutional governance and the rule of law. And the
Mr.
specific...
Stokes, what exactly are you saying is violative of the Constitution?
I'm saying Kojic as applied. Obviously, just some background. Jones versus Wolf discuss two constitutional permissible means, basically the strict interpretation of the legal neutral principles of law. The Tennessee Supreme Court adopted Wolf some 40 years later of the legal neutral principles of law. Okay, if you look very specifically, and it's in my brief, and I forget at which page, but it quotes, and if you read the language, and in essence, the Supreme Court stating, you can settle these property disputes before they arise. What you have to do is form some legally cognizant written document that all judges, lawyers are familiar with. Contracts, deeds, change the articles of incorporation if there is a corporation. It has to be.
How does this relate to the ecclesiastical abstention doctrine, which was the basis for the granting of the
Because
motion?
the ecclesiastical abstention doctrine absolves us from dealing with these issues, and these aren't religious issues. These aren't doctrine or polity. These are
So are you
laws.
saying that the ecclesiastical abstention doctrine is violative of the Constitution, or just the way it's applied in this case?
I'm saying as applied to all matters, it is unconstitutional because it violates the Establishment Clause and the Equal Protection Clause. Furthermore, COGIC does not treat property laws, contract laws, trust laws, business organization laws, recording statutes, or the statute of frauds equally because they treat churches differently. The COGIC case does.
Well, that's based on the First Amendment, right?
Correct. The second reason that appellants aver that COGIC's application violates the state and federal constitutions is the Establishment Clause. The Establishment Clause, boiled down, basically states that the government cannot create laws that establish a religion or give potential or preferential treatment to a certain type of religion or a certain religion. Again, in Martin, Justice Cope describes the true purpose of the Establishment Clause was not to place religion above the law, which the application does, because they don't have to follow the same laws that every other man, woman, and child has to follow. It was to assure that Americans were not forced or mandated to follow a certain religion or a type of religion, like the Church of England or other 1800s institutions. The key purpose of this constitutional amendment is neutrality in the law. Again, Justice Cope states and defines the law or the application thereof cannot favor one religion over another type, nor can it prefer religious adherence over non-religious adherence. Basically, all laws need to be secular laws. There is possibility where there is crossover, but the fact of the matter, property law is a secular law. Just like we don't allow churches to be free from murder. We don't allow churches to be free from theft. We don't allow churches to be free from sexual abuse. And as this court's recently ruled, the ecclesiastical abstention doctrine is not even a defense to a defamation lawsuit. So these are hugely important matters. The second main category that appellant severe allows them to prevail on all these issues in appeal is the illegality or the violation of public policy. Have an article here that's from the New York Post. It was also published in the Commercial Appeal in Shelby County.
Have you seen this?
Yeah. Just use it.
Is
Just
this
use it for
a piece
reference.
of evidence that's in the
No,
record?
Your Honor, this is just for reference. I'm just showing and stating that there's individuals that are sitting in Shelby County Jail right now for fraudulently quitclaiming deeds to parties and then selling them. This is essentially the same conduct we're accusing the appellees of, because they do not have a single document that shows that they have an ownership interest in our property. And it's the crime of theft of property. The appellees' only interest that they claim that they have an interest in our property is from a book. It's called the Book of Discipline. These are 3 different versions. This is from 1950, 2000, and 2016. The trial
And that's
court.
the book that all of the churches within the United Methodist system agree to abide by?
I don't think, I don't think they've ever agreed to abide by them. I think it is part and parcel of what is placed upon them. I would point out that it's not a contract, it's not a deed, and I'll address other matters with the book here in a minute. But again, in the matter of Dick Broadcasting versus Oak Ridge, which can be found at 395 Southwest 3rd, 653, and it's another Tennessee Supreme Court case from 2013. And again, Justice Coke speaks about it. He says, courts should tread very cautiously when asked to recognize and enforce implied obligations that are not reflected in a written contract. Again, I would state, this is not a contract. If anything, it is a demand for property. And to the record, there's not a single document in the entire record that the appellees produced that shows they have an interest in the properties that are under dispute. There's not a deed. There's no example of a merger which they claim to protect their interest.
Their claims are based on the Book of Discipline.
That's it. That's what the trial court hangs their hat on. That's what they hang their hat on.
Has Bethel been functioning and operating as a United Methodist Church?
Say what? I'm
Has
sorry.
Bethel been functioning and operating as a United Methodist Church?
Not since 2019.
They still have that name.
They go by Bethel Church, and they actually changed their corporate name in papers before this lawsuit was brought. We didn't file this lawsuit. We were actually sued by a third party, which is an alleged other church, and then we countersued them and countersued the appellees.
I believe your time is up.
Can I just add something real quick, because I didn't even get to my third
No,
point?
your time is up. You'll have rebuttal time.
That's fine. Thank you very much.
Good afternoon, judges. My name is Heather Anderson of the Knoxville Bar. May it please the court, I represent the Holston Annual Conference and the multiple individual third-party defendants named in this case. We are here today because the local church, Bethel United Methodist Church, within the hierarchical organization of the United Methodist Church, sought to leave the United Methodist Church and Holston Annual Conference through a process called disaffiliation. The Book of Discipline, which was referenced by the Appellant's Council, is the foundational governing document of the United Methodist Church. It was adopted through the General Conference, and everyone is to abide by it if you are affiliated with a United Methodist Church. It establishes annual conferences as the fundamental bodies of the church. It is the book of laws for the UMC. In 2019, the UMC adopted Section 2553 within the Book of Discipline. This was entitled Disaffiliation of a Local Church Over Issues Related to Human Sexuality. It created a process by which local churches could apply and leave the United Methodist Church, leave the conference. The Book of Discipline, much like the official manual in the Kojic v. L.M. Haley case and the Constitution or Book of Order in the Holston Presbytery versus Bethany Presbyterian Church case, contains a trust clause. And it says, local congregations hold their real property in trust for the benefit of the church, even if there's no trust language in a conveying deed. Appellants say there's no document, there's no deed conveying our interest to the United Methodist Church or the conference. According to, I call it well-settled precedent in Tennessee. I think 8 years is a pretty long time. There doesn't have to be conveying language in a deed in order for this trust clause to apply. Bethel UMC has admitted it was an affiliate of the United Methodist Church. It reaped benefits. We appointed pastors. It was part of the pension program. They had our signage and attended General Conference.
So in answer to Judge McClarty's question earlier, this church was a part of the Methodist Church,
Indeed.
an active
It was,
part of it.
and they admit in their third-party complaint to being affiliated with the United Methodist Church. There's no dispute there. Bethel simply did not follow the process set out in the Book of Discipline, but instead filed a lawsuit asking a Tennessee court to declare the trust clause in this Book of Discipline is invalid on its face. Or in the alternative, Bethel asked for it to be appointed the trustee of its own property and to be able to do whatever it wants with its real property. The trial court in this situation took 11 and a half or so months to decide this case. We argued it on June 5th, 2023. We did not receive the opinion until May 28th of 2024. The trial court assessed the situation and correctly decided that the civil case hinges on the process under which a local church may disaffiliate itself. This wasn't about a piece of property. It wasn't about finding the correct owner of the property. It was about a local church seeking to move away or disaffiliate from the United Methodist Church. The trial court went on to correctly find Bethel's characterization of the claims at issue as a property dispute are nothing more than a ruse to import secular law into bona fide dispute regarding the governance and administration of the law of the church. So we ask that this court affirm the trial court's decision on appeal. The trial court even went on in looking at the ecclesiastical abstention doctrine and dismissing the first 3 counts of the third-party complaint. The trial court looked at hybrid neutral principles of law and arrived at the same outcome. The trial court, pursuant to Holston Presbytery and Blue versus Church of God, looked in the Book of Discipline, there's a trust clause. There does not have to be language in the conveying deed. I'm satisfied the church is the beneficiary of this trust. The local church can't just leave the United Methodist Church and take its property with us because that property is subject to the trust clause.
Ms. Anderson, if they had followed the disaffiliation process, would the property have remained with them?
Yes, if they would have followed the process set forth in 2553, just like in Holston Presbytery, they would be disaffiliated from the church and they would have full ownership, fee simple title to their real estate. Now, there is a dispute between French Broad United Methodist and Bethel United Methodist over ownership of the parsonage. I think it was shared between those 2 entities. But French Broad.
But the disaffiliation process, in theory, allows a church to disaffiliate and take with them whatever property they may have.
Correct, as long as they followed the process. And
Okay.
there were several churches who left the United Methodist Church. Bethel did not apply. They were not one of those churches. Instead, they filed a lawsuit.
Just to be clear, this appeal does not involve any of their dispute with French Broad.
That's correct, Your Honor. It does not involve it, and it is still remaining as a case in the trial court, although it was stayed pending this appeal. The trial court dismissed the first 3 counts of the complaint, which were a request for judicial declaration that the trust clause was invalid and a modification request of the trust clause. Based on the ecclesiastical abstention doctrine. As to the next 3 counts, 4, 5, and 6, the trial judge dismissed those based on failure to state a claim. One of those was the obligation of good faith and fair dealing and fiduciary duty. They were clumped together in count 4. The trial court said, there's no contract here, thus we can't have a breach of the obligation of fair dealing and good faith. Also, it's not an independent cause of action. As to the fiduciary duty count in the third-party complaint, the trial court found there's no duty established and there were no damages alleged. So that count was dismissed on failure to state a claim. As to the next count, which was fraud and abuse of process, the trial court dismissed those claims. They were against the individual defendants. The trial court found Bethel failed to plead specific conduct taken by any individual, and also found that all the individuals named as defendants, third-party defendants, were members of the Holston Annual Conference or trustees of the conference. Therefore, they were immune from any lawsuit. This court... we ask that the court affirm the trial court's decision. There are grounds of he was wrong on his motion to recuse. The trial court spent 38 pages explaining why the basis to recuse did not exist. The allegations were a congressman walked through the courtroom with papers, and then someone didn't feel right about it and went searching on the internet and found a photo of Ms. Cruz, who is a member of French Broad United Methodist, and Congressman Burchett. So Ms. Cruz filed an affidavit that's part of the record. Her testimony was she did not have a relationship with Congressman Burchett, did not know him personally. He had nothing to do with their case, and the affidavit was not controverted by the appellant in this case.
And the judge, in fact, said that his discussion with Congressman Burchett had nothing to do with this case, and they did not discuss this case. Is that correct?
That's correct, Your Honor. Yes. As to the civil conspiracy count, I know appellants raised an issue that the trial court did not discuss that in the memorandum order. I agree this claim was not addressed by the trial court, but this court can affirm the trial court's dismissal of that civil conspiracy claim with a modification. It can also be dismissed. An appellate court can affirm a decree correcting result, but rendered upon different, incomplete, or erroneous grounds. And as you know, this court construes the complaint liberally, presuming all factual allegations to be true. So if
the amended order say that there's a dismissal of all claims brought by third-party plaintiffs against third-party defendants?
Yes, Your Honor.
So that would include this claim, would it not?
Yes, I think it technically would include that, and that was the order pursuant to Rule 54. So if you have no further questions, I'll rest. We urge the court to affirm the trial court's decision that the motion to dismiss was granted correctly. And also, Your Honors, we have asked for attorney's fees to be awarded to Holston Annual Conference for a frivolous appeal. If you look carefully at the basis for the appeal, there's no facts under which this court could set aside the trial court's decision. And so we would ask that attorney's fees be awarded to the Holston Annual Conference. Thank you.
Thank you. Mr. Stokes.
Thank you, Your Honors. Just to finish my argument and then address some of Ms. Anderson's points, and if you have any questions. The third thing that I said is the facts of the case and the evidence. If you look to the facts of the case, there's nothing, no documents whatsoever. They admit it, it's only the trust clause. The application of that is illegal. The very first maxim of any real estate transfer is that you have to intend to transfer property. If you read the words in Jones versus Wolf, they're all plural. It says, they, the parties, may. They can all take these actions. Just because they sua sponte say, I own that piece of property, that's not true. Imagine if I sued you individually and I said I owned an interest in your home and I didn't bring forth a single document except for, hey, I sua sponte wrote these rules that says that. If that's the law, I could start a nonprofit organization with my son, say he's basically a homeowners association. He belongs to a National Homeowners Association, which, when you're comparing it to the UMC, does not legally exist. They're not a business entity. They are not authorized to do business in the state of Tennessee.
Counsel,
he could make his, excuse me, I'm sorry.
I think you agreed that your client, up until 2019, was affiliated with the UMC.
I would say loose affiliation. I believe those are the exact words in the pleading. But like
Did they operate under the Book of Discipline?
No, they did not. But what they did, the Book of Discipline is not like an operational book. And if they're saying it's a constitutional charter, how's it a constitutional charter if you don't even exist? The only thing that they do for those people is, yes, put a signage in front of your church. And that could go along with my analogy. If my son says he owns a homeowners association, he puts a sign up there that says Stokes Homeowners Association. We belong to this national one. It doesn't exist. 10 years down the road, people want to leave. Just because he put that sign in the yard, you're telling me he's entitled to that house and to those people's bank
How
accounts?
does your client get its pastors when it was working as a loose affiliate of the UMC?
I believe that they pick them, but I know the church pays for them. My clients, this isn't like SMU or anything like that. They've made no contributions to my client's property, and they've owned these properties since the 1940s and the 1890s. They were allegedly created by a merger in 1968. How do you acquire an interest legally without that being theft, without them intending to give it to them? If my clients would have signed a trust agreement or a contract that says, hey, we give this to you, we're doing it, but that's not the case. And just like I said, as far as the record indicates, we have 42 deeds. All they do is quit claim the deeds because they don't own an interest. They just claim they own an interest. And we have people sitting in jail for doing the same exact thing. How is that not meet constitutional standards?
Is that the reason why your client did not follow the disaffiliation process? Because
No, my clients had already left and didn't do anything with them, and prior to this starting, they changed their corporate structure, and we didn't file a lawsuit like we keep hearing from Appellee's counsel. We got sued by a fake church because after they were told directly by
Well, you
the...
filed a third.
Correct, but we
party
didn't
complaint.
initiate this lawsuit. They left, they were doing their own thing business-wise and everything else, and all this came up because the whole common scheme and fraud that is very evident from the record in the emails and the communications between the direct superintendent, Mrs. Cruz, and Attorney Stephen Walling, and the documents that I was telling you about that we have in there. We have real deeds. We have utility easements. We have things that prove this merger never occurred. It was a scheme to try to keep the property with the church, because that's what this is all about, is money. That's what it's all about. And she didn't tell you those are one of the conditions. They had to pay an extortion fee to leave, which was to the tune of about $1 million, I believe, this past year for the churches that did leave.
That's in terms of allotments, is it not?
What do you mean by allotments, Your Honor?
Well, as I understand it, each church is supposed to contribute to the bigger church, and each church is assigned amounts of money that they pay. And
You mean a random, arbitrary, capricious number that they come up with?
no, I'm not going there.
Okay.
So wasn't that money you're referring to allotments?
No, Your Honor. It was
No?
pay this fee to leave, and you can keep your property. And it was random,
Did I not
arbitrary,
read
capricious.
something in the record
And
that said allotments for the next year or something like that?
They also said it was in regards to a shortage of pension retirement, which is managed by a third party. So how's there a shortage? How do they have any control over it?
Okay. I took a little bit of your time. You got a minute.
You're fine. Your Honor, just in short, I believe if you truly, Your Honors, excuse me, if you look at the case and you look at Jones versus Wolf and you look at the language in there, one word in a contract can interpret different meanings. What they're saying that meets constitutional muster is the parties have to do this. They can't just sua sponte say it, because the real world application is that destroys titles of our law and it makes them above the law. And just like if I buy a house, I have to sell it, I have to record the deed. There are laws that have existed since the 1800s that we all must follow. My question to you is, why don't they?
Thank you very much.
Thank you very much for your time, Your Honor.
Thank you all. Would you call the next case, please?